Good afternoon, everyone. Thanks for coming out on a rainy day. I'm Tom Lenny. I'm the director of the McFarland Center for Religion, Ethics, and Culture here at the college. The McFarland Center sponsors a range of conferences, lectures, special events on a range of questions that explore basic questions of meaning, morality, and mutual obligation. Our talks are online. You can see them at holycross.edu/McFarland Center, and in a few days, today's talk will be posted online too, so you can tell your friends what they've missed. In June, as you all know, in a ruling in the case of Dobbs versus Jackson's Women's Health, the Supreme Court overturned a precedent that had been established in 1973 in Roe versus Wade, the landmark abortion case. Roe ruled that a right to abortion, which was not explicit in the Constitution, could properly be derived from or implied from within the constitutional right to privacy. I hope I got that right, exactly right. And we all know that Roe's evocation of the right to abortion has been controversial. So too is the privacy-grounded legal framework that underlies the decision. Even Ruth Bader Ginsburg, I'm told, questioned whether the right to privacy was an appropriate grounding for a constitutionally derived right to abortion. She believed in the right to abortion, she just, I think, would have gone at it in a different way. Now that the constitutional link, though, has been privacy and abortion has been severed. But abortion is not the only right articulated by the Supreme Court on this foundation. Access to contraception, the anti-sodomy laws that are in place for the last 20 years, or overturned in the last 20 years, the right to same-sex marriage, those are all things that are also grounded in a right to privacy. And many wonder whether these will survive in the future. A famous, some would say infamous alum of the college, Clarence Thomas, Justice Clarence Thomas, thinks that the constitutional rulings on these should also be revisited, and I presume by implication, overturned as well. I'm not going to steal our speaker's thunder on these questions, but I merely want to indicate how much is at stake when we talk about the right to privacy. I haven't even touched on all the areas of media and other areas that we could go into. It shapes our laws and our lives a great deal. And it's easy to forget, too, that that right to privacy didn't just drop down from the sky, that it's been contested, that it's grounded in a history. In fact, we were talking earlier about how it's grounded in part in history in my own little town, my neighborhood with a few people, so we were looking at the map about those places. In the Me Too era, many of those who favor the application of privacy under Roe would be deeply uncomfortable with some of the ways that the right to privacy has supported things that we would find highly problematic. So to help us consider these distinctions and to consider privacy's tangled history and its tenuous post-Dobbs future, I'm really pleased to welcome Amy Gaida. Amy is the class of 1937 professor of law at Tulane University Law School. She's a former journalist. She told me, in fact, that she was a reporter on television, and she was a TV host, news host, while she was in law school. She's an internationally recognized expert on media law, privacy law, and higher education law. She's author of the critically acclaimed Seek and Hide, The Tangled History of the Right to Privacy, which is what drew her to my attention, published earlier this year, and two previous books, The First Amendment Bubble and The Trials of Academe. She co-authored case books on mass media law and the law in higher education, and has published a number of scholarly articles and book chapters. She's published invited opinion pieces in the New York Times, Wired, Slate, Time, among others, and she's regularly quoted and appears in media in The Guardian, The New Yorker, Marketplace, C-SPAN, and CBS Morning News. Her weekly commentaries on legal issues aired on Illinois public radio stations and won 7 Associated Press awards. A first-generation college student, Gaida is the winner of both the Felix Frankfurter Award for Distinguished Teaching and the President's Award for Excellence in Teaching, Tulane University's highest teaching honors. So please join me in welcoming Amy Gaida.
Thank you. Thanks so much for having me. As I said, I'm delighted that you came out on this rainy day, and thank you, Tom, for inviting me. I'm delighted to be talking with you today about the history of privacy and its tenuous post-Dobbs future, but you'll see that asterisk that I put after tenuous, and I think you'll understand then by the time I get done with this talk what I mean why I put that, that asterisk there. If you know anything about privacy, maybe you won't be surprised that this is then my first slide. Her name was Marion Minola, and she was a Broadway actress in the 1890s, late 1880s and right around 1890. She took this photograph in a studio, and it was scandalous for the day, because women were never pictured in tights. They wore dresses that went all the way to the ground, and so she had agreed to take this photo to advertise a play, and then was later horrified to see the image in posters on the streets of New York, and was especially mortified because her daughter saw this image as well. So she vowed never to have her picture taken in this way again. She was performing on Broadway one night, and out of nowhere, there was a camera flash, and someone, a photographer, had captured her image in tights like these on the Broadway stage. And so she sued. She sued for the right to privacy, arguing that, that she had a right in this image, that she could decide whether someone could capture her image like this, even though she was performing for a large audience, and she won. So she convinced a court, and a court ordered that the negative be destroyed and that the photograph never again, or never be published. And so some people think that that was the very first right to privacy lawsuit or case in the United States. But I'm not going to start with Marion Minola, really. What I'm going to start with is this U.S. Supreme Court. And as Tom suggested, the court just a few months ago looked at abortion and overturned Roe versus Wade. And what the court did in doing that is it suggested that there were two different types of privacy. The first type of privacy was the right to make and implement important personal decisions without governmental interference. So that was one type of privacy, this right to autonomy, if you will. But the court suggested that there was a difference between that and this other type of privacy, the right to shield information from disclosure. So abortion had to do with the first right of privacy and not then the second. What the court held is that a fundamental right has to either appear in the text of the Constitution or be deeply rooted in the nation's history and traditions. And so I am going to share with you my take on privacy in a post-Dobbs world. As tenuous, as I suggest here, is the right to make and implement important personal decisions without governmental interference is today in a constitutional sense. The right to shield information from disclosure is both deeply historical and robust and growing, even at the Supreme Court. This is highly relevant to the future of the right to privacy and information, even under Dobbs. It could lead to a constitutional privacy right in information, even while constitutional autonomy rights remain in doubt. But as enticing as privacy itself is, and as strong as the calls are for this different type of privacy today, it's important to remember that the right to privacy has been in conflict with the right to know from the very beginning of the United States in ways that threaten democracy, and therefore balance with regard to this other type of privacy is inevitable. So I won't be starting in the 1890s with Marion Minola. I'll actually be starting in the 1600s and the 1700s, the very first rumblings of a right to privacy in the United States. This is the very first long-form newspaper in the United States, published in Boston in 1690. As a part of the very first edition of this very first long-form newspaper in the U.S., the reporters, the journalists who put this out, included information that the King of France was having an affair with his son's wife, with his daughter-in-law. And so very immediately, in the government then, in the colonies, shut that newspaper down. So very first long-form newspaper shut down, arguably, at least in part, on privacy grounds. That's not it. Even before the First Amendment was ratified, so in the late 1700s, the founders had this real dilemma. And so they recognized, and this is William Cushing here on the right and John Adams on the left. And what they discussed was, we have this new First Amendment that promises freedom of the press and freedom of speech. Does that mean that any publisher can reveal what they called instances of male conduct? They suggested that's sexual dalliances outside of marriage. And they were really worried that this First Amendment that sounded so expansive would then allow that sort of publishing. So they had this discussion. Cushing writes to Adams, would it be wrong to punish a publisher who accurately revealed the politician's instances of male conduct? In other words, would punishment for such a publisher be allowable despite the First Amendment? And John Adams says, absolutely yes. That sort of scandalous truth told without any honest motive would be punishable despite freedom of speech and freedom of the press. So again, this recognition, they didn't call it privacy by name, but a recognition of the same sorts of things that we think about when we think of the right to privacy. In the early 1800s then came a legal argument for the right to privacy, and that is thanks to these two, and also a newspaper called The Wasp. The Wasp reported back then that Thomas Jefferson, on the left, had paid people to say nasty things about George Washington. Newspapers at the time had also reported that Jefferson was having a sexual relationship with a woman he had enslaved named Sally Hemings, and that they had had children. Jefferson, of course, even though we think of Jefferson as being very much about freedom of the press, etc., Jefferson did nothing when the government shut those newspapers down, including The Wasp. The reason Alexander Hamilton is here on the screen is because he represented The Wasp when the government came to shut it down. But Hamilton didn't argue that the First Amendment protected that sort of publication. Here's what Hamilton argued. Unrestricted publishing would be a terrible liberty. And so one of the founders, Alexander Hamilton, suggests publishers should be punished for revealing a man's personal defects for the purpose of disturbing the peace of families. And so because the newspaper had this sort of argument made by its attorney, the newspaper lost that case, and the editor of The Wasp then was fined and also imprisoned for a short time for revealing that information about Thomas Jefferson. Given that sort of history, a number of court cases then started appearing in the early 1800s in the United States. The first one involved a love letter. It was a love letter sent to a woman by a man who had a crush on her. And in it, he revealed his love for her. She thought this quite humorous, and so she gave the letter to a newspaper to publish. The man who sent the letter was horrified and said, and asked the newspaper not to publish it. The newspaper wanted to, and so he went to court, arguing that he had a right to privacy in the information he had revealed in that letter, even though he'd openly shared it with this woman. And a court found in his favor. So a court suggested that when we send letters to people, that doesn't mean that they have the right to take that information revealed in the letter and share it with anybody else. That stuff in letters can be family secrets and that sort of thing that would otherwise be protected on privacy grounds. I think that case was from 1805. Shortly thereafter, the US Supreme Court, meeting at the Capitol in those days, suggested that a newspaper that reported that a man had the itch, which was a sexually transmitted infection, could be punished despite the First Amendment. That sort of information should be protected then on privacy grounds. Again, they oftentimes don't use the word privacy, but they sometimes do. And then also there was a case in New Hampshire involving a newspaper that had suggested that maidens had attended a party where they'd been kissed. And those maidens then brought a claim against the newspaper, and they were successful. So the newspaper was not allowed to publish such information, even though it was true. So the 1800s continue. There's a line of privacy cases throughout. But then what caused people to be really up in arms were advancements in technology. And those advancements in technology included the sorts of cameras that allowed people to take pictures of Marion Minola on the Broadway stage. But the advancement also allowed the newspapers themselves to publish photographs sometimes, and also sketches from photographs. So people were up in arms about the media and about technology and those sorts of advancements. This is one of those newspapers. This is the New York Illustrated News, and there on the cover, this is from 1890, there on the cover is a woman lying in a hammock and enjoying the summer's day. This is then the headline from that newspaper. Caught by a camera queen, a society young lady of Red Bank, New Jersey, while sunning herself after her morning bath, is photographed in her gay and limited attire by a snapshot from a stranger's camera. And sure enough, there is the young woman with her blouse falling down just so, and right above her knee is the photographer holding a box camera, capturing her. Again, this is in 1890, hiding in the bushes to take her photograph. Cameras didn't only look like that back then. They literally marketed cameras at the time, suggesting that if you went up to someone with a book like this, they would never know that it was a camera. Some cameras looked like purses. Cameras were small enough suddenly to be able to fit into pockets. And this is an ad for this book camera, and you see here that they're literally suggesting that this is a detective camera, allowing people to sneak up on others then and take their photographs without the individuals knowing that was happening. And so also here in Boston, then two Boston lawyers got together and decided that something needed to be done with regard to the law. Their argument was published in 1890 in the Harvard Law Review in perhaps the most important, or at least most famous law review article literally of all time. They called it The Right to Privacy. In it, they argued that media is out of control, technology is out of control, and something needed to be done about that in law. The man on the left is Sam Warren. He was a paper millionaire, so his family had made its money off of paper. He was then a fellow student at Harvard Law School with Louis Brandeis on the right. And the reason why he's his law partner, and the reason why I use this picture of Louis Brandeis is because Louis Brandeis suggested that this was the one that he liked the most at this time, and that he destroyed all the others. So they make this argument in the Harvard Law Review, this plea for privacy, but both of them have pretty interesting backstories. Sam Warren, the man who had appeared on the left there, was really good friends with President Grover Cleveland. And President Grover Cleveland had some pretty scandalous stuff in his past. And among other things, President Cleveland had started dating his basically adopted daughter when she turned 18. And they married when she was about 21 and he was about 50. They married then at the White House. And Cleveland was so irritated that the media would be interested in this sort of relationship and his past, and so he made this argument. Silly and mean coverage of his personal affairs and ghoulish glee desecrated every sacred relation of private life. Such coverage, he said, was an outrage upon all the privacies and decencies of life. And as president, he said he deserved the same right of privacy that publishers expected for themselves. And so you see those sorts of arguments in the right to privacy. Again, Sam Warren was really good friends with Grover Cleveland. And in the right to privacy, there's the suggestion that even politicians should have privacy in some of their past life. Louis Brandeis here had an interesting backstory as well, certainly not as scandalous, but interesting nonetheless. This is a book called Cape Cod Folks, and the author of this book was a school teacher who went to a small town on Cape Cod and worked in a schoolhouse for 2 years. What she did was she took fastidious notes of all of her interactions with the people who lived in this small town, and thereafter put it together, writing a story, and called it a novel. But she used these people's real names, and all of the stories were true. This is the front piece of the book. This is a sketch of Grandpa Fisher. That was his real name. These two women are also real people, and they were helping him to dye his hair black so that he might look like a man of 30, it said in the book. So Grandpa Fisher and all the other people outed in this so-called novel sued the publisher. And they made the argument that this was, in fact, an invasion of their privacy. Brandeis doesn't represent those people. Brandeis represents the publisher. And Brandeis says, sure, your privacy has been invaded here, but we don't accept this sort of privacy as law in the United States. So he basically makes the argument that law that would protect Grandpa Fisher and everyone else didn't exist in the US at that time. The case moves forward. I think Brandeis realized that he was going to lose, and so he settled the case. So Grandpa Fisher got money from the publisher, and they changed then the names of the people and some of the interactions then in later editions. So you see that notion in the right to privacy too, the argument that everyday people have a right to privacy in certain interactions and otherwise. In the early 1900s, the law shifts even more toward privacy, and this is one of the reasons why. This is an ad for a flower company, and it features a 17-year-old girl. This picture was taken for her boyfriend only. And sort of like Marion Minola, she was horrified to see a poster advertising flour then featuring her image in the grocery store. What she didn't know is that that poster had been sent across the United States and was appearing in all sorts of other places too, including bars and saloons. And so she sues for the right to privacy. And her case goes all the way up to the New York High Court. And the New York High Court says, this is not an invasion of privacy. Just because two Boston lawyers have written a law review article about privacy doesn't mean that privacy exists in law. We're not going to listen to those lawyers. Moreover, she should feel honored that she was so beautiful that the advertisers would think that she was pretty enough to advertise their flower. So people were outraged that this happened, as were legislatures. And so across the nation, lawmakers and courts started finding a right to privacy in situations like this and otherwise. By the 1930s, a group called the American Law Institute, and what that is it's a group of lawyers, law professors, and judges who get together to decide what the law is in the United States and what it should be. This is the way they described then in the 1930s the right to privacy. A person who unreasonably and seriously interferes with another's interest in not having his affairs known to others or his likeness exhibited to the other is liable to the other for invasion of privacy. And then it offered 3 different examples. Times it said, the American Law Institute said then, were a privacy invasion in the United States. The first was stalking. Stalking someone and thereafter publishing the hour-by-hour details of that person's life. Surreptitiously filming an abdominal operation and thereafter publishing the film. And then finally, photographing someone who is, quote, hideously deformed, and that's the quote from the American Law Institute. Photographing someone who is hideously deformed on the street, whose condition was caused by inexpert care, and publishing the photo with an accurate article about the need for better medical care in rural communities. In other words, this embrace of privacy in the way that many people argue then exists and should exist today. So privacy is growing, but something else is happening in the United States. And that is that newspapers like the New York Illustrated News are going away. And one of the reasons that they're going away is because journalism started to embrace ethics codes. And they started to embrace ethics codes in part because of this man. So this is President Warren Harding. President Warren Harding was a former journalist before he became president. And he was known for abiding by a strict rules of ethics. And so he lobbied his fellow journalists across the nation, suggesting that they needed to start to protect privacy in an ethics sense, that it was important to journalism itself. And so his lobbying continued, and on the very day that he spoke to the very first national convention of editors, newspaper editors in the United States, that's when those newspaper editors then enacted their very first national ethics code. This was in the 1920s. It's not clear if those journalists recognized that one of the reasons why Warren Harding wanted that strong protection for privacy in an ethics sense was because he was having an affair with a teenager. What he would do he would take her to the bridal suite and sign her in as his niece. And they had also had a child together. So he had a real self-interest in promoting a national code of ethics that respected privacy in the way that it did. So the very first national code of ethics is passed by journalists in the 1920s. It says this: a newspaper should not invade private rights or feelings, that public curiosity wasn't a good enough reason, that details of crime and vice should be omitted from the newspapers for the general good. And they said that this shift toward privacy was in direct response to complaints that reporters had assumed a right to violate with pen and camera the constitutional privacy of individuals, especially those involved in scandals or disasters. So it was a time then in the 1920s and the 1930s when gutter journalism had ended, New York Daily News or New York Illustrated News goes away, and courts began to defer to journalism. It was cool to be a journalist. Journalists abided by ethics codes. They weren't as smarmy as they had been in the past, so much so that the Walt Disney Company published this book suggesting that maybe children might want to be journalists someday. This never would have happened in the late 1800s, early 1900s. So deference then in courts begins to journalism, and this is a really good example. This is a very famous privacy case. This is William Sidis on the right. He was a child genius. When he was 12 or 13, he went to Harvard as a student, and he lectured to professors there on mathematics. They were in awe of his intelligence. So he became very famous nationally and internationally. When he became an adult, he decided he didn't want that attention, and he became what was considered a hermit at the time. So he stayed to himself in his apartment, but he did teach some classes there on subway tokens and other unique, intriguing topics that he was most interested in. The New Yorker decided to do a story, a Where Are They Now story on him. And so what the magazine did was they sent in a reporter undercover to one of his classes. And they then published this article in the middle, the article that they called April Fool, because Sidis was born on April 1st. In it, they talked about, or they revealed what he'd said at his apartment. They talked about what his apartment looked like, and Sidis then sues for invasion of privacy, and he loses. The intermediate level federal appellate court, a very influential federal appellate court, decided that the New Yorker had the right to decide to do a story on someone like this. Someone who had been a child genius, and that it was important, for example, for parents to understand what might happen to their genius child if they push their child too much. So Sidis then loses his case because of that deference to journalism. The same thing, then increasing deference occurs as journalists report from the front lines of Vietnam, from the civil rights movement, and that is they break the story of Watergate. This is another example. This one is from the 1970s. This man here with the yellow arrow is Oliver Sipple. Oliver Sipple was attending a talk by President Gerald Ford, and noticed in the crowd, he was a former Marine, noticed in the crowd a woman about to assassinate Ford. And so Sipple then very bravely, grabs the weapon and saves President Ford's life. He became a national hero. Shortly thereafter, gossip columnists began reporting that he was gay. He hadn't told many people, he hadn't told his family, and his family disowned him. And so he sued then the newspapers, the gossip columns for reporting this. Again, a very influential court decided that the newspaper had the right to reveal such a thing. They bought the argument, the newspaper's argument, that it was important for the American public to understand that gay men could be brave too. And that's literally what the court suggested. So that sort of public education, the court decided, was more important than what Sipple considered his private life. So in 1977, the American Law Institute goes back and takes a look at all these privacy cases that had been decided from the very beginning through 1976, and they break up privacy into 3 different torts, 3 different legal wrongs. And this is still the law in the United States today. So this is the way nearly all jurisdictions define an invasion of privacy. The first is misappropriation. the use of someone's image in advertising, just like that flower of the family example. Intrusion into seclusion, the peering in on someone when they're in a private space. And the example I like to use with my students is a camera set up in a public bathroom stall, for example. That camera is instantly an intrusion into that person's seclusion. Nothing needs to be published about it. The camera itself is an intrusion into privacy. Another example is hacking into someone's phone, hacking into someone's laptop. Instantly intrusion, you don't have to share anything with others about what you found. If you do share, then it's a tort called publication of private facts, and this, again, exists today. But what the restatement authors suggested, what the American Law Institute suggested, was that journalists themselves, sort of this deference to journalism itself had the right to decide what was newsworthy and what wasn't. And so at the time, in the 1980s, certainly media was mainly free, and scholars literally wrote law review articles suggesting that privacy was dead. It was the time when cops started, when there were TV shows where, and these still exist today, where cameras follow ambulances around to record accident scenes, and the National Enquirer thrived. By the late 1800s came what I like to call the watch out period. And the reason why I call it the watch out period is because of this man. This is Judge Abner Mikva. He was a judge he was a progressive judge appointed by Jimmy Carter to one of the most important intermediate level federal appellate courts in the United States. And he literally warned journalism that there was a backlash coming. He'd spoken with his colleagues in courts across the nation, and he wrote this in 1995. Watch out, exclamation point. There's a backlash coming in First Amendment doctrine. And so he suggested that his colleagues believed that media was out of control and that something needed to be done to reel back those rights that media had gotten then over the course of time. Congress didn't listen much. Why? Because Congress was interested in growing this new thing called the internet. And so in the interest of growing the internet economically, Congress in 1996 passed this law, Section 230. And here's what it says. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. What does this mean? It's why Reddit exists today. The only reason why Reddit exists is because of Section 230. Without Section 230, Reddit would be liable for every defamatory comment posted there or every privacy invading bit of information posted there. It's why Facebook exists. It's why Twitter exists. It's why there are comments to news stories on news sites because of Section 230. The poster is liable, but the website itself is not. And Section 230 also continues to be the law today. So it's no wonder that in the early 2000s, people were saying you can do whatever the hell you want on the internet. No problem, and that was true for a time. Same thing, this deference to media continues as well. This sort of sense that, that courts hesitated to second guess, to edit publishers. This is one example. There was a woman who'd been raped, and her rapist videotaped the rape. And she saw this VHS tape in her apartment, plugged it into her VCR, and saw that her rape had been recorded by the rapist. She gave that video to the police. The police then gave it to a TV station, and the TV station aired portions of that rape. She sues for invasion of privacy, and she loses. The court says, who are we to second guess journalists? We refuse to edit journalists that decide that something like that is newsworthy. And besides, by airing the tape, the TV station proved that the rapist did, in fact, record the rape. So that real strong deference then continued in the early 2000s. Section 230 then leads to even greater privacy invasions. And I should say, well, I'll come back to this. This is then a picture of a college student passed out on someone's floor. And I'm the one who's made her unrecognizable through my white circle here. She's very recognizable on a website called The Dirty. What The Dirty did and does is it invites people from around the world to send in photographs and stories of people. And so someone took this student's picture while she was passed out on the floor and sent it to The Dirty with the story about how dare she come to our party and drink too much when she wasn't invited to the party at all. Section 230 then makes The Dirty not responsible, not liable in law for that publication. It's also why so-called revenge porn websites exist. It's why there are websites that publish nude photos, generally of ex-love sent in by some scorned lover. The website itself is not liable because of Section 230. The people who send it to the website might be, but the website itself, because of Section 230, is not liable for invasion of privacy in those sorts of situations. Judge Mikva was right. And I like to think that this case was one of the very first instances that helps to prove this. In 2012, the Gawker website published a sex tape featuring professional wrestler Hulk Hogan, and without his permission. So he asked Gawker to take it down. Gawker refused, and so he sued for invasion of privacy, and he won. And he won significantly. The jury decided in 2016 that he should get $140 million for the publication of that sex tape. The case later settled for $31 million. And what happened after that case made huge headlines. And so suddenly people realized that maybe we do have privacy. And then also plaintiffs' attorneys recognized if we bring privacy claims even against the media, maybe we're going to win those privacy claims. And so, so the pendulum began swinging back with strength toward then a right to privacy. So today, privacy is reborn. Why do I suggest this? I suggest this because of three examples. Do we have a right to be forgotten in the United States? Some courts say yes. So we might think of that as being this European concept, and yet some courts suggest that we do have a right to be forgotten, especially in older criminal histories and mugshots. And so you see courts being very worried about older criminal information appearing online and about the misuse of mugshots. There are some websites, for example, where they make games out of mugshots, match the mugshot to the weapon, match the mugshot to the crime. And the reason why they get these mugshots is because they're public records, that when I was a journalist, we routinely got mugshots like this. Courts and legislatures are now deciding that these things should no longer be given to the public, and they're literally suggesting that older criminal information be taken off the internet. So, for example, one court wrote, the details about one's criminal past are likely not newsworthy 25 years after the fact. So this real recognition then that some people are being harmed even by information that was once public record and certainly public knowledge. My other example is privacy in public. Is there privacy in public? Courts today, very influential courts, have said yes. And they've said that we have privacy in public in places like a crowded restaurant. And the court that decided that heard a case, who decided privacy in a restaurant, heard a case in which someone went to a luncheon invited by someone else. Unbeknownst to the person, he was being recorded, likely through a camera and audio recording that looked like a pen. So technology that looked like a pen that allowed that sort of recording. And so courts have suggested that we have privacy in a crowded restaurant when technology is used, even in a public park when technology is used to record us. This is what one court wrote. Any suggestion that there is no privacy in a conversation that occurs in a public place is wide of the mark. So if technology is used in that way to record surreptitiously, yeah, you can have privacy in your conversation that occurs in a public place. Is there data privacy? You know, we hear so much about everything on the internet, and we have no privacy on the internet today. That's not the way courts and legislatures are deciding things today. So there are a number of states that have passed very strict data privacy statutes, and courts are taking those statutes and they're deciding in class action lawsuits that people have a right to privacy, for example, in their faces, and that technology that can figure out who we are and scrape the internet for more information about ourselves can in fact be an invasion of privacy. So this is just wild, the fact that courts are deciding as much and that legislatures are passing these sorts of statutes. This is what one court wrote recently. The release of another's personal reading information to data mining companies that thereafter mix it with highly detailed demographic and personal information can be a privacy invasion. So we have a very, very strong data privacy as well. I suspect that, as I suggested earlier, that even this Supreme Court would embrace privacy in this sense, and I suggest as much because it did this just several months before it decided the Dobbs opinion. And in that case, what had happened was there were a number of donors to charities. And the charities argued that they shouldn't have to reveal who those donors are to the state. That the donor should have some level of privacy in what charities they donate money to. And the Supreme Court suggested that that was right. And this is what then the court wrote. The court said, there are privacy concerns even in commonly available data. Mind you, this is less than a year before they decide Dobbs. Anyone with access to a computer can compile a wealth of information about anyone else, including such sensitive details as a person's home address. So such information can be kept secret by charities, even from the government. And one of the real worries of these justices was doxing, the revelation of personal information online by people. So this was before they themselves were doxed after the Dobbs opinion was released. So in fact, this is why I know that the justices would be all the more concerned about this type of privacy today in a post-Dobbs world. So why do I use the word tenuous? And Tom sort of suggested a little bit of this before I started speaking. There is considerable post-Dobbs worry about the future of that other type of privacy. What the court suggests is that other type of privacy. Roe versus Wade and its line of cases found constitutional protection for contraception, same-sex relationships, and marriage equality. These were based upon autonomy springing from the Constitution, as I suggested earlier, the right to make and implement important personal decisions without government interference. By deciding then in Dobbs that states could regulate abortion because the Constitution did not protect it by word or by history, and because the justices decided that any constitutional right must either appear in the Constitution or be deeply rooted in the nation's history and traditions, there's worry then that states might one day be able to regulate those other things too. That fundamental rights built on personal autonomy, like those cases were, could go away then, just like Roe versus Wade did. Second, the reason why I suggest privacy is tenuous is while there are consistently strong calls for greater information privacy today, and while it's deeply rooted in the nation's history, and literally these are things that have happened within the past few days, weeks, and months. I don't know how many of you saw just a few days ago, the University of Wisconsin volleyball team had taken a video celebrating in the locker room. Many of the women were partially nude, and they were celebrating their championship victory. Someone just a few days ago released it to the internet. And so those women then at the University of Wisconsin are arguing that they have then a right to privacy in that video. Ashley Judd and the Judd family now are making the argument that they have the right to privacy in the death scene of their mother by suicide. And what happened in that case is that police came with body cameras and they interviewed then Ashley Judd and her sister about their mother, Naomi Judd, and those tapes then are considered public records. And so therefore what the Judd family is doing is they're making an argument based on privacy, that they have the right to privacy in that information, in those recordings, in those photographs from the death scene. This is also partially the argument that Vanessa Bryant made in the Kobe Bryant helicopter crash case, where a police officer showed images of Vanessa Bryant's husband, Kobe Bryant, and also their daughter, deceased, at a helicopter crash site. And then finally, of course, California, that's been very, very strong on data privacy protections, has enacted an even stronger data privacy bill, and that's coming into law, meaning it's going to people have to start abiding by it in January of 2023. So we have that, remarkably strong protection for information privacy then in the US. But we have to remember, even as strongly as we feel that the right to privacy then should be protected, it's important to remember that privacy can also protect the powerful. And so it protected Grover Cleveland, it protected Warren Harding, it also protected Thomas Jefferson to some extent. And one of the reasons why we have not yet seen Donald Trump's income tax returns is because his lawyers made the argument in part that he has a right to privacy in them. And so, consider when we have these calls for privacy and we want to embrace it so very much, it's important to remember that it can also protect the powerful. So what I suggest is there should be a balance in cases involving the right to shield information from disclosure. That as good as privacy sounds today, privacy will not and cannot always win, because strong press and speech freedoms are vitally important in a democracy, and without them there would be a chilling effect on crucial reporting. But freedom of speech and freedom of the press cannot always win either, because an individual's privacy is important too. Truth is not always what's most important. Dignity is a concept that's found not only in court opinions and information privacy cases, but it also appears in journalism's own ethics codes. And so it seems to me an important consideration for judges in these sorts of invasion of privacy cases, and it can be a helpful guide for judges as long as they're very careful with that word. Law balances concepts like this all the time. I teach my tort students about reasonableness. I teach them about offensiveness. What do those words mean? Many times we have to balance them. We give it to a jury at times to make those calls. The other interesting thing is that the American Law Institute is redrafting its privacy sections, so we'll need to see what comes of that and how it suggests then within the next 5 years or so, the law is moving forward and should move forward in a privacy sense. So I'll end with where I began, and that's Marion Manola. And I think it's interesting to think about what the court said in Dobbs about this right to information privacy being different, and that any constitutional right in this sense has to be deeply rooted in the nation's history. So I make the argument that a right of information privacy is actually constitutional even in a post-Dobbs world as we are, and that maybe even Marion Manola would have then a constitutional right to privacy in an image like this one. So I'd love to take questions now, and if you have any questions that you want to send me yourself, if you don't want to ask them here today, please feel free to send them to me at this email address, and I'll do my darndest to respond to you. Does anybody have any questions?
First of all, thank you.
Sure. Thank you for coming out.
So there's a mic for the sake of the people who will end up watching this on the recording, but if you're too shy to get up to the mic and you still want to raise your hand and ask a question, you feel free to do that. Professor Yule is not shy.
I'm like your students, but I'm so angry I have to. Stephanie Yule, Professor of History. So I have two questions for you. One is on the issue of reasonableness, and one is deeply embedded in the nation's histories and traditions. Given the fact that abortion practice is a centuries long practice, given the fact that it has its origins in founding of this country in terms of settlements, given the fact that women had a right to determine quickening until the mid to late 19th century, how is it then that that issue of privacy can be determined on a notion of history? Right?
So,
the idea of the bodily autonomy privacy. That's the first question. I'll ask you the other one.
Sure.
I'll sit down.
Sure.
The second one is reason. Both things are coming from a feminist perspective.
Sure.
The other is the issue of reasonableness. How is it possible that it's unreasonable for Gawker to publish Hulk Hogan having sex, but it's reasonable for a woman's rape tape to be published?
Mm-hmm.
Can you unpack that for us a little bit?
Sure. So let me first respond, of course, to your first question, and that is that what the court did was the court looked selectively at history, and a lot of this has to do. One of my frustrations to some extent is that my book came out just before the Dobbs opinion came out. So in other words, just before. And I really think that there's a lot of rich stuff in there that supports the sort of argument that you're making here, right? So this historical basis. A lot of it has to do with the briefs that were written to the justices and what the justices decided to use from those briefs. And so the justices get to decide what is then, the most relevant to them. And so, as you suggest, a number of historians and others are up in arms about this. Your question, actually, about the Hulk Hogan tape versus the rape tape is a really wonderful one as well. And my best answer is that courts back in the 1990s and in the early 2000s had just decided that the First Amendment trumped nearly any sort of privacy case. I mean, if you think about it, all of us in here probably have grown up with the notion of what freedom of the press and freedom of speech means. We hear it all the time. We hear about Thomas Jefferson. It's freedom of speech, freedom of the press. We all have the right to say the truth. Courts think that true too, even though, as I hope I've convinced you, it's not always true, and it hasn't been throughout the history of the United States. But it's an easy way to decide these cases. The press gets to decide what is newsworthy. Here, the press decided that portions of the rape tape were newsworthy, therefore, who are we to second guess? Who are we to edit that sort of decision? By the mid-2010s, which is when we started getting, when the Gawker opinion came down, favoring Hulk Hogan, courts felt far more emboldened to second guess journalism's decisions. And I think one of the reasons why was because it's basically impossible to tell what is journalism and what isn't. You know, in other words, is anyone on Facebook a journalist? Or is there something special about the New York Times? And if there is something special about the New York Times, well, how does Gawker figure into that? And so suddenly, courts started deciding cases in favor of privacy, just as Judge Mikva suggested, being sick and tired about this sort of notion that the First Amendment would protect any sort of truth. And so today, we have a lot, I don't think that rape tape case would be decided the same way today. In fact, I am like 99% sure it wouldn't be. Because you have a number of cases, here's another one of interest, involving an NFL player who, for the New York Giants, who had been somehow playing with fireworks and had one of his fingers blown off. He had to have it amputated, Jason Pierre-Paul. ESPN reported that he had had his finger amputated and included in its tweet a copy of Jason Pierre-Paul's medical chart. Jason Pierre-Paul, famous NFL player, then sues ESPN for the revelation of that medical information, and court decides that he can win. A court suggests that even though he's a famous person, and even though this was highly newsworthy at the time, that his interest in protection for medical information was more important than ESPN's ability to publish that sort of thing. So again, the pendulum has decidedly swung back. And my point here is just that, as I think your question also suggests, we can't embrace privacy too much. Because if we embrace privacy too much, we're never going to find out about presidents' medical conditions, about those running for Senate in Pennsylvania, about those sorts of conditions. And so it's a very interesting time in which today privacy is winning out. You know, we all want privacy, we want data privacy, we are absolutely getting it. But we have to remember that we don't want to cloak these other people, including presidents, with privacy, because that would destroy democracy, our understanding of politicians, among other things, before we go into the voting booth.
Alex looks ready to ask a question.
Yeah, I was ready. Thank you very much for this. I was curious, in the Dobbs decision, where they clarified the idea that this particular right to privacy has the potential for human life associated with it as a way of qualifying perhaps the other contraception, gay marriage. Are there ways in which the court would reinvigorate the right to abortion on equal protection grounds or on some other grounds other than privacy that would avoid some of these kinds of difficulties that you've identified in tort law?
Well, one of the things that I find deeply intriguing is, sort of goes to your first question as well, is that I think that given what I have found about protection for medical treatment in the course of history, about protection for men and their sexual dalliances, protection for the itch, sexually transmitted infections, those sorts of things, rich historical precedent for protection for those sorts of things. I think that given the right court, and that would mean an intermediate level federal appellate court that wanted to find its way around Dobbs, that it would be possible to find its way around Dobbs given precisely that. And you see this working, at least right now, in some state courts, where state courts will find then this right to privacy inherent in their own state constitutions. So that's one way. One of the interesting things, I think, today is this publication of private facts tort. So one of the conflicts is the publication of private facts tort. Traditionally, if we were having this conversation a year ago, I would have said abortion is protected as being non-newsworthy. It's medical treatment. It's absolutely protected as not being newsworthy. We're going to protect people's privacy in cases of abortion. The interesting twist now is that crimes have always been newsworthy. And so the argument might be by someone that creating a website and posting on that website the names of every woman who's had an abortion then would be not a publication of a private fact because of the news value inherent in the crime in those states in which it is a crime. Now, again, sort of thinking about your question, that's the sort of case where I can picture a court then embracing the sort of constitutional privacy that I'm talking about. And I will say that it's not just me who sort of has recognized this line of cases suggesting constitutional privacy and information. The Supreme Court itself suggested this. So the Supreme Court has routinely suggested that there is a right to privacy and information, even in cases in which newspapers won, very famous cases. The court routinely says there is a clash here between two constitutional interests, one, the right to privacy, and two, freedom of the press. We're not going to decide that today, we're going to decide it at another date. So you have that rich history as well. So we'll have to see what happens in those sorts of cases. But I do think that I really hope that people making these arguments in the future will in fact pick up my book and read through those things and find some fodder to make these sorts of arguments. I see it as a lawyer. I see it as a lawyer, by the way, who is married to a former Supreme Court clerk. I can tell you with confidence that I think that these arguments are valid ones. Yes.
So I have two questions.
Sure.
The first one being, with the rape tape, how, if at all, do you think that case might have been changed if the woman had decided to sue the police department rather than...
That is a fantastic question. I'm so happy you asked that question. The answer, so the question is, how would that case have been different if the woman had sued the police department instead of suing the press? And the answer is she did. She did sue. And I think what happened is that case, I think it was never fully decided. I think they settled. But what's highly relevant to your question is that that's one way that, that privacy is being protected in these ways. Has anybody ever seen The First 48? It's a show that follows detectives around as they're investigating a murder. And in the program, they go to the scene of the murder. They interview people who are suspects, et cetera, et cetera. What police did in one of those examples, or one of those episodes, is they gave the First 48 producers video of someone's interrogation. And they also took video of this arrestee walking down the hall of the police department. He sued, not the First 48, but he sued the police department, and he won. The court decided at an I think it's an intermediate level federal appellate court, so again, a very crucial, important federal appellate court, decided he had a right to privacy in that information, and that the government had violated that right to privacy, and he therefore had the right to sue the government. So I suspect, again today, that she would win her case against the TV news station, but that she would also win, as I think she did, if I remember correctly, at least in terms of settlement, the police as well. Yes?
Just going back to those two cases as well, the sex tape and the rape video, are there any cases where that has been reversed based on gender, or do you think that would have been reversed if it was a male who had the rape video or a woman who had the sex tape?
So I think that that's a really important question. I do think that gender plays a role here, and a very important role. And one of the things that has always frustrated me as a woman who has been studying privacy since the very beginning of the internet, basically. I started teaching privacy in 1999. The internet really began in the mid-90s, is this notion of Section 230. Because Section 230 is the reason why these revenge porn websites exist. And 85 to 90% of the people whose nude images are published there are women. And when I would make the argument early on, the suggestion was, hey, First Amendment, if they don't like it, they can sue. Well, the problem is, of course, they can sue, and if they sue, they then suddenly become it's made public additionally. And also, they have to sit through a trial of some public interest, but they're also likely not going to get any money, because the person who did that probably doesn't have much money, an ex-boyfriend, ex-girlfriend sort of thing. And so it's always been a great frustration to me, and I do wonder if those had been men outed in that way routinely, whether Congress would have amended Section 230 before this point. Congress did amend Section 230 in one way. What happened was maybe 5 or so years ago is some underage victims of sex trafficking brought a claim against Backpage.com, saying Backpage.com uses our image to facilitate sex trafficking, harming us in ads on Backpage.com. A court decided that Section 230 protected Backpage.com. That because of the protections of Section 230, Backpage.com was not liable to these underage victims of sex trafficking. And so Congress amended the statute to change that. But your point is a really, really good one, because I do think that that it's a very gendered sort of thing. Again, being around when the internet started, I remember interacting, and I don't know if this is available someplace on some message board from like 1996, but I remember saying something like, hey, maybe we shouldn't be revealing this, because I'd been a journalist and I knew it was inappropriate ethically. And so I said, hey, maybe we shouldn't be revealing this, and having instantly people shut me down and say, what are you saying? This is the internet. We have First Amendment rights here. So it's a very intriguing question. Yeah.
Just a follow-up to the...
And people, of course, should feel free to leave if they want. I'm happy to stay for, as you can tell, I'm very passionate about this subject, so I'd be delighted to stay as long as people have questions.
As a follow-up to the case of the TV show, I was just wondering, I've seen videos of the interrogation of the Parkland shooter.
So you've seen videos of the interrogation of the Parkland shooter.
So I was curious how you think that would come in relation to a similar case of the show, and if it's different since it's newsworthy.
Sure, that's exactly right. And so therefore, if we have the interrogation of the Parkland shooter, that's a different sort of news value. You can see then, that's an important thing for people to see, to try to better understand what the heck he was thinking, how he behaved, et cetera, that sort of thing. So I would make the argument that there was great newsworthiness in that sort of interrogation. And that's ultimately then why I argue that there has to be a balance. We can't say that, all interrogations are off limits. We can't say that even all sex tapes are off limits, which might be surprising, but, consider, if there's a tape of a president engaged in a sexual relationship with spies or, something like that, an example that I've been using literally for 2 decades now, that you know, maybe that sex tape, maybe we would want to see that sex tape. Maybe the news value in that sex tape was so important that it wouldn't go the way of the Hulk Hogan case. So that's that balance that is so irritating at times because we're never really certain how a jury is going to decide or a court might decide it. But yet I think it's important for that reason. Yes.
Thanks for a great talk.
Sure.
So I feel like the kind of overall argument that you're making is that we should have confidence in the kind of staying power of privacy as a right because of the historical, you know, the history of it in the nation and in the law. And that's obviously what the Dobbs decision says is the reason that they made the decision that they've made. But at the same time, I know there's been a lot of commentary from historians and legal experts, I'm neither of those, about the fact that the historical analysis that was done in Dobbs was not well done at all. And you mentioned yourself that a lot of it was, in essence, kind of cherry-picked from what was submitted to them, and that there's things being left out everywhere because the Supreme Court are not experts on history, just like they're not experts on you know, mathematical modeling when they make decisions about things like how do we determine what's gerrymandering and what isn't, which they've decided cannot be decided even when experts tell them that it can. So I guess my question is, why should the public have confidence at a time when there is a lack of confidence that any of the decisions going forward will be made on anything that is based in the actual history, the actual science, the actual facts?
Sure, and that's a wonderful question too. I have some confidence, I will say, some confidence that there will be courts that will in fact embrace these things. And I can tell you that there are courts that are embracing these things. And I will tell you that pre-Dobbs, there was something called stare decisis that suggested that that courts in the future should abide by those sorts of decisions. And the best, my most hopeful self believes that there will be really good lawyers out there making these sorts of arguments in ways that will convince, you know, even some court out there, maybe even the Supreme Court itself someday, that they need to think about these things in a different sense. And again, what they suggest in Dobbs is that this is a very narrow decision, again, focused exclusively on abortion. You know, my hope is that in looking at the history, in looking at the sorts of cases that are in my book and otherwise, that maybe they will suggest historical support for some of these things. But you know, I am not confident in that. In fact, I lack confidence in that. All I can tell you is that there is support for it, as you recognize in history and in precedents.
Thank you. We have to take a break.
Sure.
But some people are coming to dinner. So
Okay,
we got some
great.
of us signed up for dinner.
Wonderful. And if you're not, I'd be delighted to come up and please feel free to come up and ask me questions right now. Thank you all for coming again. Thank you.
Thank you.